Hello and welcome back as we discuss more mistakes our parents and grandparents had made that we're suffering for. So today what we're going to be talking about are NFA items a collective right? So the question is, does the Second Amendment protect NFA items as well as all items? Or is the NFA part of it, is that a collective? You have to be in like the National Guard or the militia or something like that to be able to exercise your Second Amendment when it comes to like full autos, grenade launchers, etc. You know, fill in the blank, XYZ. So the reason this even comes into question is because there's a legacy, and that is the NFA legacy. I've made specific videos on where it came from, the ridiculousness behind the law, and the ridiculousness that the law is still in effect. Yes, it's being torn down. It's gonna go away. It's just a question of when. So where are we at right now? Right now, what they're hanging their hat on is a Scalia decision made in 2008 in the Heller case. Understand, Justice Scalia was a genius, and he was awesome. He had been indoctrinated that the general average person was no longer responsible enough to have military-grade weapons and to do anything he can to prevent the general population, the collective of people, from being able to obtain such weapons. Remember, he was born in 1936, lived to 2016, and he got into the Supreme Court in 1986. Those were all huge turning points when it comes to firearms restrictions. Never before the 30s was there ever allowed a firearms restriction on the general American population. There were some restrictions, like for example the Black Code, but the only reason that was allowed to stand was because they didn't consider black people a person. So because they weren't a person, they weren't an American citizen, therefore they could be restricted their Second Amendment rights. Anywho, as that went away, as Native Americans and black people got their citizenship, while the gun laws that were applied to them carried over to the rest of the nation because they felt that black people and Native Americans still weren't responsible enough for guns, so we need to restrict them. There's little things in history like, oh, we're doing it because of the gangsters or something like that. It didn't restrict the gangsters. One, they had more than enough money to pay for the tax, and that's saying that they even want to pay the tax. I mean, we're talking about criminals here. Why would the criminals decide to pay that tax? Anywho, kind of went off in the weeds. So in Scalia's decision, he had ruled that, yes, the Second Amendment as a whole is not a collective right. You do not need to be in a militia in order to exercise your Second Amendment right. However, he puts a clause on there using a two-step approach saying that, now, I agree that the Second Amendment is all-encompassing, it protects all firearms, but balancing it against public interest, when we're talking about dangerous firearms, those are only protected under the militia. Now you're probably like, but what? The militia is literally in the Second Amendment. Like, that's one and the same. The Second Amendment, the militia, they go together like peanut butter and jelly. How can you say that dangerous weapons are only protected under the militia, but not to the average person, when it's all in the exact same paragraph? Well, he justified it like this. So what he did is he said, Article 1, Section 8, that says that there are two different militias, one that Congress can call and one that's us, the people. Any able-bodied man from 16 to 60. So because there's two different militias, and then he basically just started talking out of his ass. And he said that, so it's been traditionally proven that all dangerous weapons are only protected by Congress's militia, aka the National Guard. So let's take a look at the Second Amendment. It breaks down into four different parts. 1, 2, 3, 4. It breaks down a little something like this. Understand, I'm not a legal expert. I'm not a lawyer. I'm not giving you legal advice. And if you take legal advice from me, you're stealing. This is my interpretation of the Second Amendment. But remember, all this stuff was written so the average person can understand it. You don't have to be a lawyer to understand the Constitution, the Bill of Rights, anything like that. You should just be able to read it and know what it means. It was written intentionally that way. Anywho, so it breaks down in four different parts. Number one, it talks about the militia. It needs to be well regulated. Well, The anti-gunners got hung up on that. Oh, regulation, there it is, right there. That's the power granted to the government. No, regulation meant something different back then. Like they specifically talk about a clock being regulated. What regulation meant back then was in good working order. So it talks about a militia in good working order, and then it talks about state security. My interpretation of that is the state itself has a protection from the federal government. This way the federal government can't put like some sort of, I don't know, federal gun law in place. Like, I'm just going to pick something out there. The NFA or the GCA, something like that. That is not okay. The state itself is protected from federal regulations on firearms. Because remember, the Second Amendment is strictly about firearms and what power will be afforded to the government. So then it goes on to the third part. It protects the people. Keep and bear arms. And then you go on to the fourth part. What exact power does the government have with the Second Amendment? Because remember, the Second Amendment isn't a document from the government to the people giving them some sort of license or some sort of right to have firearms. Your rights already exist. Just being born in America, you are automatically afforded all gun rights. What the Second Amendment does is reaffirms it and puts a restriction on the government. So what power exactly is given to the government in the Second Amendment? That would be, shall not be infringed. They have zero, count it, zero power when you're talking about regulating the Second Amendment. This is what the Second Amendment looks like right here. Remember, this is from the people to the government. The Constitution even starts, we the people. This is the people talking to the government. As you look through these different sentences, is it considered a sentence if there's a comma and not a period? I'm not 100% sure. Anyway, as you look through these different lines, there is no power whatsoever afforded to the government to restrict firearms in any way, shape, or form. So now, back onto the Heller decision. Article 1, Section 8. So what exactly is Article 1, Section 8? Well, Article 1, Section 8 is the power to call the militia. And this is where he really starts talking out of his ass. Because he says Article 1, Section 8, which looks like this right here, says that there are two different militias. It's the power to call the militia. Not a militia, not a new militia, not a second militia. It's the power to call the militia, indicating that there is only one militia. If Congress intended there to be more than one militia, they would have used different wording. They didn't make mistakes like that back then. They would have said the power to call a militia, or a second militia, or a new militia, or Congress's militia. No, it just says the militia, which brings you back to the Second Amendment, saying that this does not have a second part to it. There is just one militia, a well-regulated militia. Okay? Moving on from there. So then he goes on to say that dangerous weapons are covered only under Congress's militia, which we've already established doesn't exist. There isn't a second militia. There is only one militia, because otherwise they wouldn't have called it the militia. Dangerous weapons are only covered under the Second Amendment, under this make-believe militia that he just literally made up in 2008. This has never existed before. And that's how it is. Well, if you look at it, there's nothing talking about an express privilege for dangerous weapons. It just says the power to call the militia. So, has there ever been a designation between government and civilian weapons, or government and militia weapons, or civilian weapons and the militia weapons? No. The government, especially the Army, has always turned to the civilian market to get their arms. Always. Until 1983 with the M16A2. That was the first time ever that I know of that the government actually put out like, hey, this is what we want. We're going to make this firearm specifically for us, and it's going to be restricted from the civilian market. All the way before that, the M16 he brings up in his argument, because he's talking about M16 as a dangerous weapon. Don't forget, that was a civilian rifle. That did not start off as a military rifle. That was a civilian rifle held by civilians or citizens. And then they got caught up in the Vietnam War and they realized that their armament sucked because it was outdated. So they turned to the civilian market and they're like, hey, that rifle actually works really nice. Yeah, we had our biases against it and we said that we were never going to take it, but we were wrong. So we would like to purchase a bunch of those rifles. And they purchased them from Colt, and then it became a military rifle. Now the M16A2, that was a little bit different. That didn't start off as a civilian rifle, that started off as a military rifle. That's the first time in history. So there's no tradition, history, or text backing up this idea that this magical second militia that doesn't exist had some sort of special ability to firearms. Civilians have always, until 1983, had better firearms than the government. This was the first time in history. So, what is the NFA, you may ask? The only reason they were able to pass it in the first place is because the NFA isn't technically a gun law, it's a tax. However, they decided they're no longer going to collect the tax after 1986, which then it's no longer a tax. A tax must be collected. A tax cannot be a penalty. Well, let's pretend that you could actually pay this tax, like in the case of SBRs, SBSs, or silencers. The Supreme Court has affirmed on more than one occasion you cannot tax a right. A right is untaxable. Even the sales tax on firearms is unconstitutional. But we're still just trying to get to the point of NFA, because remember, it's still a legacy that's been carefully protected by the Supreme Court because they're still afraid a bunch of black people are going to rise up and take over the government. We all know that's not going to happen, or at least we don't think it's going to, so it's a ridiculous law. Let's get rid of it. So the NFA can't be taxed. Now here's where things get interesting. In the Bruen decision in 2022, they decided from now on we are only going to be looking at Second Amendment cases with text, tradition, and history. And then they even dated. So we're not talking about 2008 Scalia decision, text, tradition, and history. We're not talking about 1934, or I should say 1939, NFA tradition of text, tradition, and history. They said 1971. 1791. I knew I was saying that wrong somehow. So 1791, were there in fact any restrictions separating military firearms from civilian firearms? Absolutely not. As a matter of fact, at that point in time, civilians had a higher quality, better grade of firearm than the military, and it's been that way through the entire history of the country right up until 1983. So prior to 1983, no, there's never, ever been any case whatsoever where the government has been afforded a better firearm than the civilian population. It's always been the other way around. The civilian population has always been better armed than the government. So, just to recap, nowhere in the Second Amendment is the government afforded any sort of power to restrict anything, and the 2008 Scalia little side notes, his little decision right there, he was completely talking out of his ass because there was only one militia. Even in Article 1, Section 8, they don't talk about multiple militias. It's just the power to call the militia. Not a militia or anything like that. Kind of already pounded that home. And yes, the Second Amendment most certainly protects dangerous weapons. In his little side notes calling the M16 a dangerous weapon, remember that was a civilian weapon first. That didn't start its life as the military. Anyway, if you'd like to help support the channel, got my Patreon right there. I also have affiliate links in the description down below. Just by clicking on those particular links, even if you don't buy what that link is for, just clicking on it and doing the Amazon shopping you were already going to do anyway, I'll kickback for it because you came there off my channel. Thank you for watching. Don't forget to subscribe. And just kidding, it's actually me. I know you didn't believe it was me because of the mask, but I just wanted to trick you guys a little bit. And obviously, because I'm shooting this video, that means that I was approved for a remote court hearing, so I did not have to drive to Florida. I will see you guys in the next video.